There is a misconception among some eligibility workers that a person cannot be in this Medi-Cal program after age 65. That is not true. A person can continue in this program after age 65. There is no upper age limit to the program. Certainly, a person who has a disability at age 64 is not miraculously cured of that disability by turning 65. Rather, the problem is that for people who are on Social Security disability when they reach age 65, the Social Security disability is converted to Social Security retirement income. When this conversion happens, the Social Security payments are no longer disability-related income and therefore no longer exempt. For many people, this means that their income now exceeds the 250% income level and they lose income eligibility for this program. If a person is not eligible for one of the previously discussed programs, then she may be eligible under another Medi-Cal program. One program for many elderly or people with disabilities is the pickle program. No, the pickle program has nothing to do with salty cucumbers. Rather, it is named after the congressman who proposed the program. This program is for people who have lost supplemental security income or SSI due to a cost of living increase in their Social Security benefits. If the person has been receiving Social Security and SSI, at some point the Social Security benefits may exceed the maximum SSI benefit level. When this occurs, then the individual becomes ineligible for SSI. Once the beneficiary loses the last dollar of SSI, she has also lost her link to free Medi-Cal. Thus, the Pickle Amendment was written into law to prevent this terrible loss of Medi-Cal benefits and to allow a person to continue in Medi-Cal though she no longer is linked through SSI. An advocate should consider this program if she sees a client who lost her SSI and Medi-Cal, generally at the first of the calendar year, because there is usually a cost of living increase in Social Security benefits which becomes effective in January of most years. There are other programs similar to the Pickle program for disabled adult children and disabled widows or widowers. Disabled adult children, or DACs, are adults who become disabled before age 22 and receive Social Security benefits based on a parent's earnings records. If the DAC is receiving SSI on top of the other Social Security benefits, and as a result of cost of living increases in the Social Security benefits, she becomes ineligible for SSI-linked Medi-Cal, then she, like the Pickles, would also continue to receive Medi-Cal. Similarly, a number of disabled widows or widowers who would otherwise lose their cash assistance-linked Medi-Cal when they reach age 65 and get retirement income instead of disability income from Social Security should be able to maintain Medi-Cal eligibility. Medi-Cal also has a few other programs for people who, while not disabled, have a serious medical condition nonetheless. These are programs for dialysis, tuberculosis, and total parenteral nutrition. These programs are for people who generally do not meet the Medi-Cal definition of disability and are not eligible for a Medi-Cal program for people with disabilities. Each of these programs only provides the specific services limited to that program. For example, if the person needs kidney dialysis, the program only covers kidney dialysis. If a person is diagnosed with tuberculosis, it only covers the tuberculosis medication and services related to treatment. Total parenteral nutrition, or TPN, is intravenously administered nutrition for people who are unable to digest regular food. The program is limited to coverage of TPN. Individuals with full-scope Medi-Cal can get these services without separately applying for these limited programs. The beneficiary's costs for services are based on a sliding scale. Unlike any other Medi-Cal programs, the state takes into account the value of one's home in determining how much the person has to pay towards their own care for some of these programs. California also has nursing facility waiver programs. These programs are based on waivers of federal law, which the state has obtained from the federal government. Under a nursing facility waiver, the state has basically said to the federal government, hey, if you allow us to disregard certain federal Medicaid rules, then we can use our Medicaid money to offer less expensive support services to people who would otherwise be in expensive nursing homes. If you waive the rules, we can move them back into homes or into community-based settings and offer them support services such as help with bathing and personal hygiene, assistance with cooking and cleaning, and training to family members to care for them. This not only would be less expensive than living in a nursing home, but these individuals would be better able to participate in their communities and be with their families. So it would be better all around for the federal and state governments and for the beneficiary. The nursing facility waivers each have a limited number of slots. Sometimes the waivers have open slots, and sometimes they don't. They are not open-ended like other Medi-Cal programs. Generally, eligibility for the waivers is limited to people who need specified high levels of care. That is, they need skilled nursing facility care. Now we come to the medically needy program. Some advocates fear working with the medically needy program because it can involve determining a client's share of cost. It is really not as complicated as it seems. The medically needy program is a Medi-Cal program for people who have too much income to qualify for other types of Medi-Cal programs. Generally, a medically needy beneficiary is someone who, except for their income, meets the CalWORKS eligibility criteria. That is, she is part of a low-income family with children. Alternatively, she may be a person who is elderly, blind, or has a disability, and except for income meets the SSI eligibility criteria. Someone who is eligible for the Aged, Blind, and Disabled Medically Needy Program, or ABD Medically Needy Program, still must meet the SSI disability and resources requirements. However, any income that exceeds what the state has set as the medically needy income level for that size family is considered income that can be spent on the person's Medi-Cal costs. For example, if an individual has countable income of $1,250 from Social Security retirement benefits, her income is too high to receive SSI, and therefore she would not qualify for Medi-Cal by way of having SSI. Her income is also too high for the Aged and Disabled Federal Poverty Level program, and so she would not qualify for that program. If she does not have a disability, then she would not qualify for the 250% Working Disabled program, but she should be eligible for the Medically Needy program. If she lives alone and is therefore in a family of size of one person, we would apply the medically needy income level for a family of one person of $600 per month. We would subtract that amount from her income, the Social Security retirement benefits of $1,250, and the difference is $650. That $650 is the share of cost for this individual. So the countable income minus the medically needy income level equals the share of cost. That is how share of cost is determined. We will not discuss how a beneficiary meets her share of cost in this webcast, but look at the resources on the websites noted at the end of this video training in order to better understand how share of cost works.